Yeah. All right, good morning, everyone. We are here this morning on the State versus Jonathan Murray and Cameron Walker, indictment 22 SC 181129. Both defendants are here. Mr. Murray is represented by Bruce Harvey, and Mr. Walker is represented by John Majeski and Julie Kurt, and the state is represented by Kay Charles. We were scheduled for jury trial, but the parties have reached a negotiated resolution, which I'm ready to take this morning. I would like to do them at the same time. And so I will have both defendants stand, and Ms. Charles will go through the plea litany, and she'll have them each answer the questions, and then we'll go along as we normally would. Y'all can stay where you are, yeah. Yeah, just stand up. All right, Ms. Charles.
Thank you, Your Honor. Will you both raise your right hand? Do you swear or affirm the testimony you will give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? You may lower your hands.
Okay, so she's gonna ask, and when she asks the questions, I'm gonna have her ask you individually. So, Mr. Walker?
Yes.
Mr. Murray?
Yes.
All right, that's how we're gonna do it. Okay, hands down, thanks.
Mr. Walker, please state your true, correct, and legal name. Mr. Murray, the same.
Is that mic on? Just touch it gently and the green light should come on. I know, you just have to speak up. Okay, or he can come to the podium. Either way, it's just, I just didn't want to block Mr. Walker's face, but it's okay. Mhm. Understood. Mr. Walker, will you repeat your name again?
Cameron Lane James Walker.
Mr. Murray.
Jonathan Murray.
Okay.
Jonathan Murray.
Thank you.
Mr. Walker, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Mr. Murray, I have the same question to you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine? Mr. Walker, how old are you?
21 years old.
Mr. Murray? What is the highest level of education you have completed, Mr. Walker?
High school.
Mr. Murray?
Did you finish, or what grade did you finish? Mr. Walker?
I got locked up at the beginning of 12th grade.
Beginning of 12th grade. Mr. Murray?
GED, right? So it's kind of good.
Okay.
That's good.
And Mr. Walker, Mr. Murray, are you both able to read, write, and understand the English language?
Yes, ma'am. Can you repeat that question, please?
I say, are you able to read, write, and understand the English language?
You speak up, Ms. Charles.
Absolutely. And do you understand that in the indictment, you were charged with the following offenses? As to counts 1, murder. However, for purposes of this plea, that will be reduced to voluntary manslaughter pursuant to OCGA 1652. Counts 2 through 4 are felony murder counts respectively. And for the purposes of this plea, those counts would vacate. Counts 6, you're each charged with aggravated assault with a deadly weapon. For purposes of this plea, that count will merge into count 1. Counts 7, criminal attempted purchase of marijuana. And counts 8, each of you are charged with possession of a firearm during the commission of a felony. Do you understand?
Hold on, did you say count 6?
No, count. Yes, count 6 is the ag assault, and that would merge.
Into count 1.
Yes, Your Honor. Mr. Walker, Mr. Murray, do you understand that you each have the right to plead either guilty or not guilty to the charges?
Yes, ma'am. Yes.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time, Mr. Murray, Mr. Walker, to speak with your lawyers about all of the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorneys?
No.
Do you have the minimum and maximum sentence for each charge for which you're pleading guilty to?
Yes, ma'am.
And for the record, the minimum and maximums are as follows. As to counts 1, voluntary manslaughter, the minimum would be 1 year and the maximum would be 20 years. As to counts 5, the minimum would have been 10 years with a potential to go 10 to 20 or up to life in custody. The minimum on count 6, aggravated assault with a deadly weapon, would have been 1 year, maximum.
That's merged.
Understood, but just for the record, Mr. Berhavi, 1 to 20 years. Counts 7, criminal attempt to purchase marijuana. The minimum would have been 1 year and the maximum is up to 5 years. And counts 8, possession of a firearm during the commission of a felony. The minimum would be 1 year and the maximum will be 5 years. Do you understand?
Yes, ma'am.
Do you understand, however, this is a negotiated plea of guilty, which means the state and your attorneys, the defense, will recommend to the courts a sentence as follows. First, for Mr. Walker. The state recommends that Mr. Walker be sentenced to 40 years to serve 25 years with the balance on probation. The 20 years would be as to counts 1, voluntary manslaughter. Counts 2 through 4 would vacate. Counts 5 would be 10 years of probation. Count 6 would merge. Count 7 would be 5 years of probation. And counts 8 would be 5 years of probation consecutive as well, Your Honor. With the following special conditions, you will have no contact with the victim's family and complete a moral recognition therapy course while in custody. As to Mr. Murray, on counts 1, the state's recommendation is that he'll be sentenced to 15 years on the same count of voluntary manslaughter. Counts 2 through 4 would vacate. Counts 5 would be 10 years of probation. Count 6 would merge. Count 7 would be 5 years to serve, so a total of 20 years for Mr. Murray, and the balance would be on probation. So for Mr. Murray, it'll be a total of 40 to serve 20 with the balance on probation. The last 5 would be on counts 8. And the same special conditions, he would have no contact with the victim's family and complete a moral recognition therapy course. Do you understand, Mr. Walker, Mr. Murray? The court does not have to accept this recommendation. The court can sentence you to the maximum on each charge in the court's discretion and run the sentences consecutively, which means one after the other.
Yes, ma'am.
Do you understand if the court decides to order a sentence that is different from the negotiated plea, you may have the right to withdraw your plea of guilty? Mr. Murray? Thank you. Do you understand this is a guilty plea which may be permanently recorded in your criminal history?
Yes,
Mr.
ma'am.
Walker? Mr. Murray? Mr. Murray, do you understand? Thank you. Mr. Walker, do you understand this plea may also be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Mr. Murray?
Yes, ma'am.
Thank you. Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Mr. Murray? And do you understand that you're not allowed to possess or use a firearm? Mr. Walker?
Yes, ma'am.
Mr. Murray? Mr. Walker, are you a United States citizen?
Yes, ma'am.
Mr. Murray? Are you aware, however, that there may be other adverse or unfavorable consequences as a result of your plea of guilty today, just as there would have been upon conviction after a trial for each of you? Your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Thank you. Do you understand by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Thank you. Do you understand then that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty, Mr. Walker?
Yes, ma'am.
Mr. Murray? And Mr. Walker, first, I'm going to read a number of rights that you are going to be giving up by pleading guilty today. By pleading guilty, Mr. Walker, you are giving up the right to a trial by jury. You are giving up the right to remain silent and not incriminate yourself. You are giving up the right to confront witnesses against you. You are giving up the right to the assistance of counsel hired by you or to court-appointed counsel. You are giving up the right to the presumption of innocence. You are giving up the right to testify on your own behalf and present other evidence. You are giving up the right to subpoena witnesses and compel the production of evidence. You are giving up the right to have the charges against you proved beyond a reasonable doubt. And you are giving up the right to appeal if convicted of the charges after a trial. Do you understand, Mr. Walker?
Yes, ma'am.
Mr. Murray, do you understand by pleading guilty, you are also giving up the right to remain silent and not incriminate yourself? You are giving up the right to confront witnesses against you. You are giving up the right to the assistance of counsel hired by you or to court-appointed counsel. You are giving up the right to the presumption of innocence. You are giving up the right to testify on your own behalf and present other evidence. You are giving up the right to subpoena witnesses and compel the production of evidence. You are giving up the right to have the charges against you, excuse me, proved beyond a reasonable doubt, and you are giving up the right to appeal if convicted of these charges after a trial. Do you understand, Mr. Murray? Mr. Walker, Mr. Murray, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Walker,
Yes, ma'am.
Mr. Murray. In indictment, Mr. Walker.
At this point, Judge, as you know, we prosecuted a number of motions to suppress. The court have issued rulings on the motions to suppress. One of the rights that is given up when entering the guilty plea is the right to continue to prosecute or appeal those motions. That's usually not in the colloquy. I guess this is a good point to mention that Mr. Murray is also giving up his right to continue to prosecute. His Fourth Amendment issues already ruled upon by this court, and other issues, including the demurrer that was recently filed this morning.
Okay.
Understood,
Is that
thank you.
correct?
Absolutely, thank you, Mr. Harvey. All right, beginning first with Mr. Walker. In indictment 22 SC 1811129, Mr. Walker, how do you plead to counts 1 of voluntary manslaughter?
Guilty.
How do you plead to counts 5, criminal attempt to commit armed robbery?
Guilty. Guilty.
How do you plead to counts 6, aggravated assault with a deadly weapon?
Guilty.
How do you plead to count 7, criminal attempt to purchase marijuana?
Guilty.
And how do you plead to count 8, possession of a firearm during the commission of a felony?
Guilty.
And is your guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Mr. Murray, how do you plead to counts 1, voluntary manslaughter in the same indictment? How do you plead to counts 5, criminal attempt to commit armed robbery in the same indictment? How do you plead to count 6, aggravated assault with a deadly weapon in the same indictment?
Yes.
How do you plead to count 7, criminal attempt to purchase marijuana? And how do you plead to counts 8, possession of a firearm during the commission of a felony?
Yes.
And likewise, is your guilty plea freely and voluntarily given with full knowledge of the charges against you? Mr. Murray, Mr. Walker, do you understand you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand you have 30 days from today to file a direct appeal of your plea of guilty?
Yes, ma'am.
And do you understand you have 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of your plea of guilty?
Yes, ma'am.
Thank you. Your Honor, the state is unaware of any criminal history for neither Mr. Walker or Mr. Murray. And had this case proceeded to trial, the state would have expected to show.
We'll stipulate to a factual basis.
I want to hear it because I believe you're going to ask me for first offender.
Yes.
So I want to hear it.
Okay. On October 14th of 2021, officers responded to of 12206 Collingwood Lane to the apartments there. And what officers located was near apartment 202, which is the apartment belonging to the victim, in this case, Connor Mediate. Officers found Connor's body lying in the parking lot. Just outside his apartment door. On arrival, they met with several of the neighbors who heard gunshots. One neighbor, specifically Elizabeth Lewis, had been out on her balcony and she observed what she described later as a dark in color vehicle. She couldn't make out the make or model. It was later confirmed to be a Porsche Panorama that had been circling the apartments. And so because it had been circling, she felt it looked a little bit out of place, so she began to take a film. As she took the video, she saw the vehicle exit the parking lot area and sort of go down the hill. At that point, she looked a little bit downwards towards Connor's apartment and she observed his body there on the ground. What officers later learned as a result of the canvass and speaking to additional neighbors is that one neighbor heard an outcry saying, "Get out of here," or "Get the F out of here," followed by multiple gunshots. One neighbor saw the vehicle backed in, but didn't see clearly the occupants of the vehicle. They simply described them as two black males, one of them having short dreads. Later on, officers were able to do a search warrant of Connor Mediate's apartment, and they located his cell phone. In locating his cell phone, they were able to review the contents of his most recent communications, and they were able to locate that he had had communications with Cameron Walker. That communication was to arrange the sale and buy of marijuana. Both the neighbors and Connor's phone would confirm that that is what he did. He would buy and sell marijuana to people that he knew. The phone records of Connor also revealed that he had texted Cameron Walker his address. And shortly before the incident, which happened at about 8:52 p.m., Connor texted, or on Snapchat was the method of communication, "You just went past me," and understood that Connor exited his apartment at this point. And there it gets a little bit hazier as far as the factual basis goes. What officers would later learn after speaking to Cameron Walker once he was taken into custody and he was given Miranda is that the boys did arrange to go do a buy from Mr. Mediate. And according to their testimony and their statements, Mr. Mediate entered the back of Connor's vehicle and he had a firearm. The passenger would have been Jonathan Murray. The front passenger, according to Mr. Walker, seeing the firearm, Mr. Walker indicated, the lead detective, that the firearm was either brandished or pointed in his direction, and then Mr. Murray shot. He shot once, saying, "Get out." When Mr. Mediate didn't move, he shot again. Once Connor was taken, Cameron was taken into custody, officers then got warrants for his cell phone records and his social media. In reviewing that social media information, they learned that 2 days prior, Cameron Walker had been talking to another young student at Milton High School named Asan Diakumpa, and himself and his son were discussing making licks. And according to, I guess, common knowledge or officers' knowledge, that licks would simply mean a robber. Asan and Cameron talked about the lick for a few back and forth, but then nothing came of it. That was on the 12th. On the 14th, Cameron Walker reached out to Asan and said, "I have a lick." Asan says, "All right, when?" He says, "I'm trying to do it after school," and that's on October 14th, the day of our incident. Cameron Walker then asks Asan to give him a ride. Asan, we were later able to confirm in speaking to him and just that Asan had to do practice after school, so that lick, they never got together. In speaking to the coaches at the school, the basketball coaches, because both Mr. Murray and Mr. Walker played basketball for the Milton High School, and speaking to the coaches, what they explained is that both Mr. Murray and Mr. Walker were at practice that night, and practice ended about 8 p.m. And so they both left together. In speaking to some other late witnesses, we learned that Jonathan Murray lived on his own. He would from time to time spend nights over at Cameron Walker's house. Cameron Walker's mother. Oh, sorry, I thought I was last. I'm sorry. In speaking to some lay witnesses and Cameron Walker's mother, we learned that Jonathan lived on his own. He would come and spend nights with Cameron, and it was sort of a known thing that they would hang out together. Cameron had the run of the basement in the house. It was a ranch with a basement, and he had the run, so he had his own private entrance. He came and went almost as he pleased, and she would, see him from time to time. And so she explained that night when he came home, she heard a commotion in the basement, but she didn't understand fully what was going on. She didn't go down to check. However, later, Cameron Walker would hand her a firearm, and that firearm would be placed in her closet. She says, in hindsight, she should have asked more questions, but she didn't. We later learned that after Cameron and Jonathan were left Collingwood Lane, they went to Mr. Walker's home, went to the basement, and they changed clothes, and then they went back outside and cleaned up the vehicle. In cleaning the vehicle, there were 2 shell casings recovered. There were 40 caliber shell casings. Those 40 caliber shell casings were later discovered in Jonathan Murray's book bag. At the scene of the crime, underneath the body of Connor Mediate was 1 other 40 shell caliber. And we know from the autopsy, Mr. Mediate had been shot 3 times. Fast forward to 2023. At this point, Cameron Walker has an attorney. And what transpired is that the mother of Cameron's reached out to law enforcement and says, I found a gun in my garage. When they go to the garage, underneath some cushions wrapped up in a towel is what we later found out to be a 9mm handgun. And that 9mm was submitted for ATF trace, and that ATF trace returned to Connor Mediate, which is the victim. And that sort of led to the charges that we're here for to litigate, Your Honor. In the course of the developing investigation, what we learned as far as going through Cameron's phones, going through Connor's phones, going through Jonathan Murray's phones before the motions were heard is that there was no substantive communication between Jonathan Murray and Connor Mediate. The only communications we were able to link was with Cameron Walker and Connor. We also learned that Cameron Walker and Jonathan Murray were unknown to each other. The way that Cameron Walker got Connor's information was for a friend at school, Corey Davis. When we spoke to Corey Davis, he explained Cameron Walker asked him, do you know where I can buy some gas? And he says, I know someone. And then he gave him Connor Mediate's Snapchat. And then Cameron reached out to buy. And so there was some concern on the state's side that we have historically Cameron Walker talking about licks, Cameron Walker discussing it with other members of his high school, not anything meaningful with regards to Jonathan Murray. And we do have the cell phone records that did put Cameron Walker and Jonathan Murray in the same locations shortly before basketball practice at the time of the incident at around 8 p.m. and shortly thereafter because they went back to Cameron Walker's house. We also considered the mitigation in this case with regards to some of the information in Connor Mediate's phone, the fact that the gun that was later recovered belonged to Connor Mediate, the fact that both defendants, although Jonathan didn't give a full statement to law enforcement, at some point during his testimony, he lawyered up. He said, I want to speak to a lawyer. But he did start to give some explanation of what happened, and also on his jail calls. When he spoke to his father, he explained that I did this in self-defense. We also considered the age of the defendants. We are, I think that on both sides, the consensus is this was a very tragic and unfortunate set of circumstances. It didn't have to happen. We struggled with this case back and forth on both sides. I think in talking to the family and Ms. Mediate, who's here today, it was a hard time coming. She's waited a long time for some type of justice and closure. One of the things she said to me this morning was, it is time to perhaps move on. That was from her perspective, understanding that them taking accountability, perhaps not to the entire indictment as charged, but them taking accountability in light of the totality of the circumstances, the exposure and potentially on both sides. This is what we would consider a fair resolution. It's not the perfect resolution, admittedly, but we believe that it accurately reflects the weight of the evidence against Mr. Walker, against Mr. Murray. And so we would ask that you accept the resolution as presented. Ms. Mediate did want to address the court.
All right, give me just, before we get there, I have some questions for you.
Yes.
Will you walk back through the counts and the negotiation? Because one of them mathematically didn't add up for me the first time I did it.
Let's see.
So if you can start with Mr. Walker, count 1 is to be
20 years.
to serve.
Yes.
Count 5,
Would be 10 years of probation,
count 7,
would be 5 years to serve. So that's the 5. So this,
Count 7 is the criminal attempt to purchase marijuana.
yes, so that's 5 on top of the 20, so that's 25 to serve for him.
Okay, and then count 8.
5 years probated.
Okay,
So maybe it's,
it should be the other way around then, because it's the possession of firearm that requires the 5 years consecutive to serve. Isn't
Okay.
that correct?
yes.
Okay,
So not,
it just has to be
not
consecutive.
Yes.
Just consecutive.
All right.
consecutive.
Okay, but you want the serve to be on the criminal attempt to purchase marijuana?
Yes, Your
and you
Honor.
want the firearm to be probation?
Yes, Your Honor.
Okay. Okay, and then for Mr. Murray,
With 15 on the voluntary,
and, okay,
and then the same 10 on on number 5, 10 is probation.
mhm. The criminal
And,
attempt on count 7,
and then the 5 and 5, 5 for 7 and 5 for 8 is all probated, Your Honor.
got it, okay.
No, I'm sorry. Let me go back. 5 on 7 and then 5 on 8 is probated.
5 to serve on 7, is that what you're saying?
Yes.
Yes, so it's 20 for Mr. Murray and 25 for Mr. Walker to serve, on the to serve portion.
Got it, okay. Okay. Ms. Harvey from Pretrial Services, do you show any history for either of them?
I do not, Your Honor. First to raise for both.
Thank you, ma'am. And Ms. Martin, I assume you don't have anything different.
No, Your Honor, I don't have anything different.
Okay, thank you, ma'am. All right. Misters Walker and Murray, you both understand the nature of the charges against you?
Yes, ma'am.
And are you, either of you, under the influence of any drugs, alcohol, or any other substance?
No, ma'am.
Has anyone threatened you in any way or promised you anything to influence you to plead guilty?
No, ma'am.
And do you understand that by pleading guilty, you give up all of the rights that the Assistant District Attorney just outlined for you?
Yes, ma'am.
And are you willing to give up all of those rights today in order to enter into your plea?
Yes, ma'am.
And do you understand that I am not bound by any promises, recommendations, or reductions, but that I can sentence you as I deem appropriate? All right. Mr. Walker, how do you plead to the charges as reduced on this indictment?
Guilty.
And Mr. Murray, how do you plead to the charges as reduced on this indictment? All right. And Mr. Walker, are you in fact guilty?
Yes, ma'am.
And are you entering your plea freely and voluntarily?
Yes, ma'am.
And Mr. Murray, are you in fact guilty? And are you entering your plea freely and voluntarily? Okay. Why don't you all have a seat for a moment? I'm going to hear from Mrs. Mediate, and then I'm going to come and hear from both of your lawyers as well. And she can come to the podium. Okay, they can come together if they like.
Sure. My name is Tara Mediate,
Okay, will you spell that for her, please? Thank you.
Taramediate.
Okay, go right ahead, ma'am.
You know, we've waited a long time. When this happened to Connor, I have 2 other sons. Being a mother and losing one, the other 2, I had to support them because they couldn't deal with losing their brother. The shock, what we've lived with. My children now, if they can't find us in 45 minutes or an hour, they think something's happened to us. Whole life has changed. Neither one of them will live where they grew up in Georgia. None of them. The pain is too awful. We've been subject to, it's every, the court has to, and I understand that's how the law works, to bring them in, and they have every excuse. Well, honestly, there's no excuses for taking someone's life. I don't care if you were, oh, self-defense, it was this. Connor would never shot somebody. Connor was the hugest heart. In his apartment, people would say, there was older women, he'd go buy the milk, he'd go buy this. His brothers are like, he would never do this. He would never do this to anyone. I wish, is this closure for us? No. Connor misses his brother's wedding. Connor's missed everything. We have a family of 5, always been a family of 5. And it's gone, and it never, ever will come back. So for 20 years, great, you know, they ruined my life. My Connor's grandmother wanted to be here. She's 90. My sister and my family, it's just been so bad. And I am trying to be strong for my other children because they have dealt with psychiatry, therapists to get through this. And even to coming here today, I mean, they're like, how are we going to handle this? I mean, it just feels like it never, ever stops. And every day I think of Connor. Connor was an amazing kid. He was my sandwich between my boys. He was the middle. And he's the one who made our family. And I was so close to him. Him and I talked 2 to 3 times a day. We've always had dinner with him. And yes, he had his struggles, but honestly, he did not deserve this, and neither did my family. And I pray to God every day. I say, why couldn't they have just beat him up? Why did they use a gun? Why couldn't they just seriously beat him up and leave him on the ground and just I could help him? Or the police said they tried to help him, but no, they just left him to die and didn't even care. So, you know, for us, I hope after today that my family will never forget Connor. It will be with us all the time. That we can move a little bit on from this after 4 years. Thank you.
Thank you, ma'am. Can I say something, Cindy?
Do.
No, switch places.
I'll be sure.
No, but yeah, but why don't you come to them like just a little bit? Yeah.
Yeah,
Yes, thank you. If you would state and spell your name, please, first. for the
my
record.
name is Joe and the last name is Mediate as well, Mediate. 4 years it's taken to get to this point. And what for? For bag of weed? You've ruined my life, my wife's life, my 2 boys, my grandmother, my grandfather, their grandmother, their grandmother and grandfather. It's unbelievable the pain and the suffering you go through with this. And the fact that it took so long and the motions and maybe it's self-defense, maybe it's this. It just, the pain is beyond unbelievable. I mean, if you've ever cried, well, this is not just crying that takes you to your knees. And not only do they ruin our lives, they ruin a lot of people around us. So whatever you decide to sentence, I would wish you'd sentence on the long side because what they've done to us is lifelong. It's forever. We'll never get over this. We will never. And the shame is they had such things to look forward to. These 2 boys from George Mason University, and just while it was dumb and stupid, I don't think this was the first time. I think it happened many times. So anyway, I just plead to you to not be lenient and to do the right thing because it's really what's going on with us will be forever. We have a life sentence. Thank you for hearing me.
Thank you, sir. All right, Mr. Majeski, if you want to come on up, and I'll start with you. Okay. And as you're coming up, my question to you is, are you satisfied that your client is competent? He understands what is going on, that his plea is voluntary, and that there's a sufficient factual basis for his plea?
Yes, Judge.
Okay, go right ahead, sir.
Speaking of somebody who deals with bad things for a living, this might be the most tragic case I've ever been involved in, including all the vehicular homicide cases I've done, because the set of circumstances that had to come together to cause this case that has done so much damage to so many people are so minute it almost kind of defies statistical probability, but it still happened, and this thing has destroyed at least 3 families that I know of. The victim's family seem like lovely people. Mr. Murray's family and Mr. Walker's family. And I don't know how much damage is done outside of that. Having said that, Judge, I have absolutely no reason to believe, but every reason to believe the alleged victim here was every bit as good as they say he was. And for that, the world is a darker place for losing somebody like that, and that just compounds the tragedy even further. I don't have any reason to believe that Mr. Walker or Mr. Murray is anything like most of the people I stand here representing on these kind of charges. They're guilty of felony murder under the laws of the state of Georgia. And this is a good resolution for them, but having spent all the time that I have with my client and talking with him and his parents, and from what I've heard about Mr. Murray, even though I've never spoken with him, I don't think the intent was anywhere close to going over there and taking some man's life. I just can't make that make sense in my head based on the work that I've done in this case, but it's still happening. It still needs to be punished because, as the Supreme Court tells us, this type of stuff is inherently dangerous, and that's why we have rules. So I think this is a good resolution. I urge the court to accept it. My client is 21 now. We'd ask for first offender on this, Judge, and I think this is going to be one of the rare circumstances where this benefits the state more than it does the defendant. I've spent a lot of time in Georgia prisons over the years, and one thing that I find is people, some men, they go down there and start doing some time. And I've had clients like this that I haven't been able to recognize as the person that I helped put in prison when they come out, because I'm looking at this refined, wise, disciplined individual who never would have thought about doing the stuff that sent them there. And I think Mr. Walker can be one of those people. So the benefit for him, because he's going to have some good years left to live once he's done serving this sentence. However, if I'm wrong, and I don't think I am, the state's got like 4 or 5 swords of Damocles hanging over his head based on the stuff we're putting him on probation for. So I say that it really does benefit everyone under this circumstance, not only him as being able to live more easily, but also the state, where if he chooses to waste that opportunity, can literally bury him without putting a single person in that box over there. Also, Judge, he's got a young daughter that he'd like to have a relationship with and maybe help support when he gets out. So I think this is a good case for first offender. I think he's a good candidate for first offender. I expect to be inspired by him someday, as I am some of my clients when he gets out. I urge you to take the pleas negotiated, Judge, and sends them into the First Offender Act. And I can say, and I do say this a lot of times the families of the defendants, they don't reach out, they don't say they're sorry, they don't do any of this stuff. And I'm the bad guy for that. I just want the victim's family to know that. I'm the one that says don't do it, because when I'm working, I don't think like a person. I don't think like I got emotions. I think like I got a job to do, and I told them not to. But I can say, as my pleasant officer of the court, they are devastated. Not just because this happened to Mr. Walker here, but because there was a loss of life here. Because they firmly believe, like I do, that every human life is precious, and the loss of anyone under any circumstance is a tragedy.
Thank you,
Thank you,
sir.
Judge.
Mr. Walker, stand up for me. You want to be treated as a first offender?
Yes, ma'am.
And have you talked to Mr. Majeski and Ms. Kurt about the pros and cons of first offender treatment?
Yes, ma'am.
So you understand the benefit is if you successfully complete your entire sentence, the appropriate paperwork will be filed, and you would be able to say, honestly say, you've not been convicted of a felony in Georgia.
Yes, ma'am.
The downside is if you do not successfully complete your sentence, you could be brought back into court. Your first offender status could be taken away, and you could be resentenced to a maximum on each charge. You understand that?
Yes, ma'am.
And understanding those pros and cons, would you still like to be treated as a first offender?
Yes, ma'am.
Okay. Have a seat for me, sir. And Ms. Charles, I know you want to be heard. I'll come back to you in just a moment. Mr. Harvey, if you would come on up, sir. As to Mr. Murray. Are you satisfied that your client is competent, he understands what is going on, that his plea is voluntary, and that there's a sufficient factual basis for his plea?
I am, Judge.
All
Thank
right.
you. There are, of course, no words that can take back the actions that occurred 4 years ago in October. There are no words that can soothe the pain to all the families, including Mr. Mediate's family. However, I will say that the recitation of facts that you heard from the state represented a pretty fair course of events, none of which involved Mr. Murray previously or communications on that day between anybody or knowledge of Mr. Mediate at all. Some of which were confirmed by those very witnesses the state would have called. So I think that the resolution with regard to Mr. Murray, who was 18 years old at the time, a student athlete at Milton, which is a very well-known and nationally recognized athletic program. The Milton football team has been in the top 5 nationally for years and years. These young men, both of them, were part of that excellent, nationally recognized athletic program. They were pursuing their, or at least Mr. Murray, and I know they both were pursuing their love in life, which was basketball, their enthusiasm for sports, their participation as student athletes was well recognized. So they were on track in their life. And then we have this tragic event. And nobody's going to say it wasn't tragic. And now Mr. Murray is 22 years old and has spent the last 4 years incarcerated at what has been recognized as the worst facility, the worst county jail in the United States of America. He has spent the last 4 years there, even though Your Honor has granted him bond, reduced the amount originally that you had required. He still doesn't have the resources to be able to maintain his freedom for the last 4 years. You know, you heard a little bit about the fact that he would stay with Mr. Murray, whose family frankly adopted him.
Mr. Walker.
I mean, Mr. Walker, I'm sorry. His father is a over-the-road long-haul trucker. So he's on the road most of the time. Mr. Murray was living essentially by himself at Rosemont Apartments. And his father, when he was completing his long-haul assignments, would come by maybe once or twice a week to check on Mr. Murray. So Mr. Murray, at 18 years old, was essentially living by himself. And when he befriended, and he was befriended by Mr. Walker and by Mr. Walker's family, that's why they hung out together. That's why they would go to Mr. Walker's house. That's why there was this relationship between them, because it was something that Mr. Walker and Mr. Walker's family took it upon themselves to help Mr. Murray. And he was grateful for that. Now, obviously, since he had a bond, his father works and works and works, but just didn't have the resources, the financial resources to be able to post bond. So we're 4 years down the road and Mr. Murray has been incarcerated for those 4 years. But even being in the worst county jail in the United States of America, what did Mr. Murray do? He got his GED. He's moving forward and wants to be moving forward and continue to be what essentially he was before this event, a productive member of society, somebody that contributes and somebody that can continue to contribute. That's one of the reasons for the difference in, I guess, the recommendations by the state. We are remorseful, exceedingly remorseful for having to stand here before Your Honor and beg Your Honor to accept this resolution and accept Mr. Murray's request for first offender treatment, which I believe he deserves and will benefit all involved. I don't think I have anything else to say.
Thank you. Mr. Murray, questions for you. You want to be treated as a first offender? Right, and have you talked to your attorney about the pros and cons of first offender treatment? You understand that the benefit is if you successfully complete your sentence, the appropriate paperwork will be filed and you would be able to honestly say you've not been convicted of a felony in Georgia. The downside is if you do not successfully complete your sentence, you could be brought back into court. Your first offender status could be taken away and you could be resentenced to a maximum on each charge. You understand that? In understanding those pros and cons, would you still like to be treated as a first offender? All right. Ms. Charles, I'll hear from the state on the first offender request.
Your Honor, yes, the state for the record that the state would oppose the granting of first offender for both defendants, just given the totality of the circumstances, the nature of the charges, the egregiousness on its face of the actions that night, not just in shooting Mr. Mediate, but then afterwards, dragging him out of the car, leaving on that cold concrete, taking efforts to delete their social media, change their appearances in Mr. Walker's case, and essentially move on as normal, as if it never happened, as if that body left on Collingwood Lane didn't happen, it didn't matter. And so we believe that understanding that they are taking accountability, it pales in contrast with what the hole that they leave in the mediator's family's lives and the totality of their conduct that night. And so we would oppose that granting. But of course, understand that it's in Your Honor's discretion.
All right, thank you. One more clarifying question, Mr. Majeski. Your client understands that he'd have to surrender by Monday. Okay.
Yes, Judge, and we've also had a conversation about, even though his probated sentence will not start until after his incarceration, this could be considered a violation of the whole sentence under Georgia case law, along with the possibility of being charged with felony escape should he not agree to turn as requested.
Okay, all right. All right, anything else from anyone before I go on with sentencing?
I don't know whether or not either of these young men wish to address the court, but I think they have the right to allocute. So that would be the only, you may want to ask Mr. Walker or Mr. Murray, but then they want to address the court.
All right. Very well. Mr. Walker, did you want to address the court?
No.
Okay, you can come to the podium, please, sir.
Yeah, I just wanted to say that to the victim family that I'm truly sorry that this happened, and I never intended on anybody's life to be taken. And if I can go back to that day and change anything that occurred, I really would. And I just want to say I'm sorry.
All right, thank you, sir. Mr. Murray, would you like to address the court? Okay, you would come to the podium, please.
Um, I would just like to tell the family that I really can't imagine the pain that they must be going through from losing one of their children. And I'm deeply and truly very sorry that those events played out that way that day. And that I will be using this time, whatever the judge decides to give me, I'll be using this time to continue to better myself as a person, and as a human being, so that when I am able to get out, I'm able to just be better and lead the kids where I'm from in a better direction. Because before this, a lot of kids looked up to me. I was their hope. And people would tell me they wanted to be just like me. They just hoped that I made it out for all of them out of my community. I was a star for my community. And I just want to be able to continue being that for my community. Thank you.
Thank you. All right, I find that there's a sufficient factual basis for the charges, and I further find that both Mr. Walker and Mr. Murray's pleas have been entered knowingly, voluntarily, and intelligently, and I will accept those pleas and sentence as the parties have negotiated. As to Mr. Walker, it's count 1, 20 years to serve. Count 5 is 10 years probation, which will run consecutive to count 7. Count 6 merges. Count 7 is 5 years to serve to run consecutive to count 1. And count 8 is 5 years of probation to run consecutive to count 5. Mr. Walker, you will need to report to the Fulton County Jail by Monday, September 8th by 12 noon. And here's the condition that I'm putting on it. If you do not show up on Monday by 12 noon, I'm not gonna file your sentence until Monday. The 2 counts that I gave you probation will be to serve instead. So my sentence on Monday at 12:01 will be 10 years to serve on counts 5 and 8. But if you show up, then it will go in just as you have agreed. Understood? All right. As to Mr. Murray, count 1, 20 to serve, 15. Count 5, 10 years probation, consecutive to count 7.
Grade 15 was what was announced.
Is it just 15 to serve?
On the count 1, for
Okay.
Mr. Murray, yes, Your Honor.
All right. Count 1, 15 to serve. Count 5, 10 years probation, consecutive to count 7. Count 7 is 5 years to serve. Is that right? Okay, consecutive to count 1. All right, and count 8, 5 years probation, consecutive to count 5. And count 6 merges.
Yes, Your Honor.
All right. As to both defendants, I will grant you your request to be sentenced as first offenders. And that leaves the ball in your court, pun intended. So it's up to you if you want your life to go in a different direction and you be on different footing once you get out, and then the time that you are out until your sentences are discharged. So it's up to you to live up to the things that you've said here today. All right. Anything further before we adjourn? Okay.
No, Judge, thank you.
All right. Now we are adjourned. Thank you.